What's up, everybody? Welcome back to the channel, to the Butterfly Monkey channel. Today, of course, will be a continuation on American Jurisprudence, 2nd edition, volume 13, on business trusts. This will be, well, it's more than 10 videos, but in terms of sequence, this is part 10 of my video sequence. And this will be part 11 in the actual chapter, in the actual book, the PDF. We're on page 147 out of 164. This will be the second from last video. There will be one more after this one. So hopefully you guys enjoy. I hope you guys like and subscribe if you guys want more, because I will be continuing to do more on business trusts, but specifically with court cases, law reviews, and so forth to back up what this chapter on business trust is actually talking about. And more so, I will try to also make it specific and detail it to a specific state. Right. So for me, I would do, of course, Illinois, but depending on responses, asking questions, and so forth, that might change up a little bit to broaden that a little bit. But for me to do that, no doubt, I need to have, either subscribers or likes for me to want that, for me to want to push that further, because then it shows that there's interested people that want to learn. If not, so be it. This is where it will end after these next couple videos on business trust. So this section, this part is part 11, practice and procedure. And this is subpart A, actions between trust and third party. So this is all court stuff or actions and whatever else. That's too ugly right there. So section 98, generally, jurisdiction and venue. An action involving the ownership of shares by and the removal of the trustee of a business trust has been held to lie in the county of the defendant's residence, so that the defendant was entitled to a change of venue to that county. But where two trustees who were properly served with process in an action against a business trust entered the appearance of the trust and thereby waived the right to have the suit tried in another county, the third trustee of the trust was held to have no right to have the venue changed. The court having jurisdiction of the trustees may adjudicate title to trust property lying beyond the jurisdiction of the court. Jurisdiction of an action instituted in a federal court in the name of the trustees of a business trust will be governed by the residence of the trustees rather than the shareholders, even though the latter may have the beneficial interest and ultimate power of control of the business. However, by answering to the merits of a local action, a foreign business trust waives objection to the jurisdiction of the federal district court on the ground of the non-residence of the defendant. Trustees of a business trust are not unconstitutionally deprived of property without due process of law by being denied the right to maintain an action in a state other than that where the trust was organized, with the laws of which it was not complied upon notes executed to it in such state. And the fact that jurisdiction has been conferred on federal courts with regard to actions on certain types of corporate obligations does not of itself mean that jurisdiction has also been conferred with respect to actions based on similar obligations of the business trust. And they don't give too many footnotes, which is kind of disappointing, right? That's why I'm in favor of reading court cases, because court cases where you're going to find, for lack of a better word, the truth tellers, right? Meaning the judges that are following the law, right? The lay of the law, right? They're not sugarcoating nothing or try to hide nothing. They're telling you exactly how it is, and those are the ones that are important to read. The supplement has, the case authority says, the citizenship of a business trust for the purpose of determining federal jurisdiction based on diversity of citizenship was held to be that of each of its members rather than that of its trustees. So this is specific to this Illinois. It looks like an Illinois case, but I don't know. NDILL. Don't know what that is. But I would like to read that. So let's look this up. Well, it's a federal case, but I want to know if it's in Illinois. Yeah, it is in Illinois. So I'll be reading that there. And that's because, they bring up citizenship. So they say citizenship of a business trust, right? Well, the only way this can be possible is that they're referring to actual natural persons, not the identity or entity of what this stands for. If, for the most part, you guys all know that a business trust or a trust in general is not separate from the trust itself. Right? The trustees are not separate from the trust itself. They are one and the same. So this right here, a little bit confusing, but they're meaning the persons involved, the natural persons involved. And that's why they say, well, that's why they go that it's not on the trustees, but in this case, it was held on the members, so the shareholders. And of course, that's going to be dependent on the context of the case. Wherein the court treated the action as one to dissolve a partnership. So that's that case. Got Orloff for 15. It says, pointing out that while business trusts may be considered as corporations within the scope of statutes using that word for some purpose, such decisions are not persuasive of the identity of the business trust and corporations when the inquiry is to determine federal jurisdiction. Section 99, parties plaintiff. It is generally held that the trustees of a business trust are proper parties plaintiff in an action to vindicate or enforce the rights of the trust estate, and that they may maintain such an action without the joinder of the shareholders. Trust instruments frequently contain provisions to this effect. Of course, that's liability, right? Thus, the trustees are the proper parties to maintain an action on behalf of the trust for breach of contract, to specifically enforce their contract for the sale of trust real property, for the protection of trust property, or to recover for damage thereto. They may maintain actions to recover for any wrongful impairment of the corpus of the trust, and may, without a joinder of the shareholders, maintain a suit to enjoin an injury to property of the trust or to quiet title to its real property. The trustees of a Massachusetts trust can maintain an action in their own names to recover rent due under a lease of trust property executed by the trustees in their individual names, without naming the trust or mentioning their trust capacity. Also, it has been held that to recover money on behalf of the trustee should sue as such and not personally or individually. And that's the whole thing, right? Like they're saying without naming the trust or mentioning. So, but the thing is, though, just because they don't mention the trust, the other aspects of how they sign or other provisions that might be in some contract or something like that, that's like what they use. And to read that, right, let's go to number 6 now. All the way down here. Don't give us nothing but Hall versus Newhall. So I would want to read this just to find out what they're talking about. So it's like, for me, this is key right here. Boom. So I'm going to copy this, put this up here and search it. Case text right here. Now, will it apply to me? Maybe not. Maybe it does. Who knows? But the thing is, it's good to follow up on such things. Under a provision of a trust instrument empowering the trustees to represent the shareholders in all suits or legal proceedings affecting the trust estate or any right or duty of any beneficiary, trustees may maintain an action as representatives of the shareholders to recover on a bond given by former defaulting trustees, running to the shareholders and conditioned for the faithful application of all funds derived from the sale of the shares, which is absolutely true. But you also have to understand that you have to write this in the instrument. You have to give the trustees that power. However, it has been held that even though the trustees of a business trust may maintain an action in their own names, when such action is brought for the benefit of others, the complainant should allege that in such a case, the beneficiary of the trust are the real parties in interest. Which it is, right? Because it's already money or a disbursement that was supposed to go to them, like property that was already going to them. So you're acting that in that representative capacity. What type of relationship that creates is depending on your state, because that could also create a partnership specifically for that interaction, for that transaction. So it depends on the state that you're in, because it also, could mean nothing. For lack of a better word, it could mean almost nothing. It has been held that trustees of a business trust may maintain an action on behalf of the trust in its adopted trade or business name, and in some states where the statutes expressly authorizing such an organization to sue and to be sued in its own name. Under such a statute, a business trust may maintain in its own name a suit to enjoin a threatened breach of contract with it and a trespass on its property, where the right of a business trust to maintain an action in its company or distinguishing name depends upon compliance with fictitious name statute. It has been held that failure of a trust to comply with such statute is merely grounds for abating the action until the statute is complied with and not sufficient reason for dismissal. So that's important, right? Because what you call your trust, that is the legal name already. In almost all cases, there is no requirement for you to file with the state some fake name, a DBA. But in some specific circumstances, depending on the activity that you're conducting, there will be a statute for that purpose. Why? I don't have a clue. Why would they want a fake name over its proper name? But nonetheless, they do exist. It's important to pay attention to that. The view has been taken that a business trust organized in another state cannot maintain an action in its own name where the trustees are not parties. And a business trust cannot maintain an action in its adopted name on a promissory note made payable to an individual without showing that the owner of the note was not such person as an individual but the trust, using the collective name of the individual. And those are all going to be case-based. This is the supplement case authority. A Massachusetts business trust authorized to transact business in Florida was the real party in interest in an action to foreclose a mortgage, and hence had capacity to bring the foreclosure suit without joining its trustees. The Massachusetts trust authorized to transact business was the real party in interest in its action to foreclose a mortgage, and hence had capacity to bring the foreclosure suit without joining its trustees. So in the individual capacity, I'm guessing here, meaning making them liable or something. A foreign business trust which has qualified to function in Florida under statute dealing with common law trust could bring an action in the common name of the trust as the real party of interest. The real estate investment trust organized under statutes specifically relating to the type of organization, which was strictly a business organization designed to deal in interest connected with land, had attributes making it an unincorporated association within the scope of another statute permitting unincorporated associations or orders to sue and be sued under the name by which they were commonly known or under which they did business and providing for the manner of service of process on such association. So here, they were created under some under a statute, but because of how they were created, they were hit as an association, unincorporated, be it, right? But an association by another statute. And they were taken to court over that. These are the annotations. This is for 17. However, the court, adopting the view that a so-called common law trust of the type herein under considered was nothing more than a partnership, held that all the shareholders and trustees are necessary parties in an action by or on behalf of the organization involving its property and rights. So this is 17. What did they say about 17 up here? It says, it is generally held that the trustees of a business trust are proper parties, right, to vindicate or enforce the rights of the trust estate, and they may maintain such an action without the joinder. So they're telling you what they're able to do generally. But down here, what happened? There was some provision, some power that made them partnership. And then the shareholders were joined. Footnote 8, pointing out that in such a case, the representation of the shareholders by the trustees is not adverse to the interest of the trust estate, because the trust estate has no claim under the bonds given for the benefit and protection of the trust. And this is what I'm saying, right? There's no adverse effect. The trust is not affected because the bond belongs to the shareholder himself. The trust estate has no interest in it. So that relationship can create something, another relationship, that relationship will create the relationship of a partnership or something like that, specifically for that action. And that's how the shareholders will get hit, right, as a partnership for that specific income. Not the whole, right, but that specific income. Trust organized pursuant to express provisions of a statute. Under a statute authorizing the creation of a trust to carry on any lawful business and generally do any lawful act in relation to trust property, which any individual owning the same absolutely might do. You gotta read for more specifics on that, especially this one. All they just told us is a trust created under some statute. And then it says under statute authorizing a creation of a trust. Whether that means that they created it under statute, I don't know. Because the terminology is similar that you would put in your own paperwork. Right? But you would have to read this case to learn more specifics on it. But that's, in a general thing. If you're not in Massachusetts, I don't really recommend it, right? Unless you're facing a federal case where these court cases might be included in your paper, in your action. Even under a statute authorizing suit to be brought by such a trust in its company or distinguishing name, the decision as to the institution of suits must be made by the trustees in whom is vested the control of the affairs of the trust. Like injuries to a trust, right? Which one was that? Number 11? And in some states where the statutes expressly authorizing such an organization to sue and be sued in its own name. But nonetheless, it's like, when there's an injury or whatever, a violation in the trust itself, it's the trustee's duty. Right? That's a principle of trust law. It's the trustees that need to bring up the issue, bring up the action. I wish they would give more. The old American jurisprudence, they give a lot more. Like, this is what you see in corpus juris secundum. all they give you is court cases all the time, just the citations. They don't give you additional information, which is disappointing, but and I think that's what's going to happen to American jurisprudence. So the books don't get fatter, and the volumes don't get expanded so much. Section 100, parties defendant. Where a business trust organization is a true trust, so that the trustees are personally liable for its debts, an action may be maintained against a trustee in its own name without joining the beneficiaries as parties defendant. And the same has been held to be true in a jurisdiction where business trusts are treated as partnership. Now, right here, they tell you a true trust, right? Because a pure trust, an ordinary trust, right? The trustees are personally liable, right? But if you have this provision, right, to make it something that it's not, right, and you have other provisions on top of this that take it away from its true nature, right? That's how you're going to get hit with this. But in most jurisdictions, this one little limited liability doesn't cause it to be removed from the pure trust standard. It has to have a higher balance of what a corporation is, a partnership, association, and whatever, which I spoke of in the other videos. But it's also dependent on the jurisdiction you're making it in. So and that's also important, right? Because, for those who want a foreign trust, right? Well, say you want a trust in some other country, Mexico, some island somewhere, whatever, right? Okay, well, you have to understand and learn their trust laws. Like, you can't come in thinking that where you come from expressly applies to some foreign jurisdiction. That's like if you create a contract and the defining terms and provisions that you have in your paperwork, right? Some other person came in and used their definitions, their terminology for your paperwork and says that's okay and that's lawful. No, life don't work like that. Contracts don't work like that. Trust instrument provisions may determine the necessary parties in an action against a business trust. Thus, where the trust instrument gives the trustees the power to sue and be sued, an action is maintainable against them without joining the shareholders. And where the trust instrument gives 2 of the 3 trustees the power to act for and bind the trust, 2 of such trustees have authority to defend actions against the trust. Well, that's an implied power, right? If you notice how they said this, right? In your provision, if you give the trustees that all you need is 2/3, right? 2 out of the 3 trustees to bring action or whatever, or to defend the claim, right? Well, then the implied authority is also that you only need the 2 to be present in court on the paperwork or present in court itself. You don't need that 3rd person. However, a single trustee representing himself and the other shareholders is entitled to maintain a defense on behalf of the trust, notwithstanding a confession of judgment by the 2 other trustees, where the latter are acting in collusion with the plaintiff in an attempt to enforce an illegal demand against the trustees. So what are these 2 other trustees doing? They're violating, they're causing treason against your trust. That's what they're doing. And as long as you're able to show that some type of collusion, right? Well, the court will uphold whatever it is that the single trustee is doing. Ideally, you would think so, right? Unless, the judge is in their pocket too, or the prosecutor and so forth. Never know. California is rough. I bet you if I look this up, there'll probably be California case too. California case. What did I say? Oh man, that's sick. That is sick. The view has been taken that a business trust is not suable in an action at law under its assumed or trust name in the absence of a statute authorizing such action. However, other courts hold that a Massachusetts or business trust may be sued in its adopted trust name, and there are statutes in some states expressly authorizing actions against business trusts in their own adopted names. In an action for tort against stockholders of a business trust who are held liable on the ground that the organization amounts to a partnership, the non-joinder of a part of the shareholders has been held not to render the declaration demurrable. Has been not to render it as a, you can't, demurrable. Let's look up what this is. Open to demur. Since I don't go to court all the time, I gotta look that up too. An objection that an opponent's point is irrelevant or invalid, while granting the factual basis of the point. An objection that the opponent's point is irrelevant or invalid, while granting the factual basis of the point. On demur, it was held that the plaintiff's claim succeeded. Formal. I'm gonna read that one. And the dismissal of an action to recover on a debt of a business trust as to some of the shareholders was held not to render void a judgment rendered against the other shareholders. These are the footnotes. Holding that a suit against a trust to recover a debt, foreclose a lien, and appoint a receiver may be maintained against the trustee as such. With a trust instrument provided that in all actions and proceedings the trustee should be deemed the representative of the beneficiaries, and that it should not be necessary to notify any such beneficiary of such proceeding for the purpose of binding or concluding him. It was held that the beneficiaries were not necessary parties to a suit in equity to recover out of the trust estate for services rendered to the trust, at least where the beneficiaries were notified by letters of the pendency of the suit and thus had the opportunity to intervene. And these things are important, right? Because there's some states that they require you to give notice to the beneficiaries, whether their parties' real interest, their interest is involved or not. Like even in the creation of a trust, like if you don't, that's just the way it is. I don't know how else to say that, but I haven't read that case. I know I haven't read that case. My list is getting long on cases I've been slacking. I've been reading some more citizenship stuff that I'm going to make a video on. So, upon the death of one trustee during the pendency of an action against the trustees of a business trust, it is not necessary to make the personal representatives and heirs parties to such action where, under the trust agreement, the duties of the deceased trustee devolved upon surviving trustees. So that should be a given. But the thing is, you have to make sure that you have this power, right, where the surviving trustee takes on the responsibility of, the one that passed. But you could do that technically with anybody. It doesn't have to be the succeeding trustee. Maybe you have a lawyer in mind, or you have a beneficiary that's in mind, something that could take over for that specific purpose. But like I said, that takes foresight, meaning that it's a possible scenario, right? So you have to plan ahead, and the only way to do that is to write it. You have to write it in your paperwork. An action based on the fraud and deceit of the trustees has been held not to be maintainable against the trustee in its adopted name. An action based on fraud and deceit of the trustees has been held not to be maintainable against the trust in its adopted name. Are they talking about the DBA, or are they talking about their legal name? The name that I'm thinking the adopted name is the name that was written in the trust instrument, right? So whatever the statute is for Illinois here, right? They couldn't file suit against them for fraud and deceit. It had to be under their DBA. I think that's how that case is going to show. Because and only because of this word right here. When they say this word, it's almost 9 out of 10 times they're talking about the name that was given in the trust instrument. Actually, 10 out of 10. I don't think I've ever seen it not used in another way. The trust having elected to operate under a fictitious name and having maintained actions in that name will not be heard to say that it cannot be sued under that name. Well, no, you're functioning under that name. Why would you think that you can't be sued under that name? You made it part of your whole trust, your whole estate. However, it has been held that in a Texas case, that in an action against a business trust, which was held to be a partnership, and against certain of its shareholders as partners, it was necessary to name as parties all of the shareholders, because it's a partnership. But in an earlier case from the same jurisdiction, it was held not to be necessary in an action against shareholders as partners to recover a debt of the trust to make all of the shareholders parties. And you have to read specifics on that to understand why. Texas case. Section 101 process. In an action against a business trust or its trustees, service of process may be made upon the trustees or in an action against the trust upon its managing trustee. Service of summons on the manager of a business trust gives the court jurisdiction of the trust where the trust agreement provides for service on the manager. And this is important, right? Because, look, to read it again, right? In an action against a business trust or its trustees, service of process may be made upon the trustees. So that's like through the door, right? First, right? Or in an action against the trust upon its managing trustee. So whoever was specifically appointed for this position to even receive the mail, right? The correspondence between, courts and so forth, right? Service of summons on the manager of a business trust gives the court jurisdiction of the trust where the trust agreement provides for the service on the manager. And that's because the trust instrument specifically said, hey, whatever process, it goes to this person. While by statute, the shareholders are bound as to their beneficial interest in the trust by a judgment against the trust in its adopted name, service must be had on them in order to obtain a judgment against the shareholders in the individual capacity. And where after service of process upon the trustees in their official capacity, the complaint is amended so as to seek relief against them personally, there must be service of process upon them in their private or individual capacities in order to give the court jurisdiction to enter personal judgments against them. So it's basically refiling. Service upon a business trust organized in another state may be made upon its trustees. Some statutes provide for service upon foreign trusts in the same manner as service upon foreign corporations. And this right here, I highly recommend that you guys read your state statutes on this, both for in a general sense, right? So that will apply to almost all entities, right? And then for trust itself, trust and business trust. Under a statute authorizing service on a business trust by serving the president or secretary thereof, service upon trustees of a business trust was held to give jurisdiction of the trust where such trustees were respectively the president and the secretary thereof, although the persons served were designated as trustees rather than as president and secretary. It still gave jurisdiction, especially if they were the same, where such trustees were, they were the same persons. In an action in New York against a business trust organized in Massachusetts, it was held that a Massachusetts statute authorizing suit and attachment against such a trust in like manner as if it were a corporation, and authorizing service of process upon a trustee was applicable. The court stating that the character of the business organization, at least where it is made a defendant, is to be determined by the law of Massachusetts and not the general association's law of this state. And that's only for one reason. The trust was created expressly stating that the governing law is Massachusetts. Meaning the interpretation, validation, right, the construction and so forth, right? Even process of law, right? That's all based on Massachusetts. That's where it was created. That's the law that protects it. Not to say governed, it protects it. The fact that a trust would not have been treated as a corporation under the Constitution and statutes of that state where it was organized was held to be without significance in construing and applying the local statute and Constitution authorizing service of process on the trust as a foreign corporation. You would have to read why, specifically for that court case. It's a Kansas case. And they took it all the way up, too. So, if you guys don't know this, LED right here, this is Lawyer's Edition. You can find this in a lawyer right here. It's usually right next to the Supreme Court stuff. It's the Lawyer's Edition, Supreme Court Edition right here. Supreme Court, United States Court, Supreme Court, Lawyer's Edition. Pleading and proof, section 102. And they give a footnote, 13. Let's go see what that is. And they give you practice aid. Denial that defendant is trustee of a business trust. And they tell you 20 American Jurisprudence pleadings and practice forms. Where the plaintiff pleads all the necessary elements to render the trustees liable on an obligation of the trust, the defendants in their answer must plead the facts on which they base their claim of exemption. Since the plaintiff need not negative a defense founded on an exception to the rule that such trustees are personally liable in the absence of an agreement to the contrary. Nor is a person seeking recovery against the trustees personally under a contract made by them required to negative knowledge on his part of a provision of the trust agreement purporting to exempt the trustees from liability. So what does it say? It says, nor is a person seeking recovery against trustees personally under a contract made by them. They're not required to show, right? Negative knowledge on his part, meaning the person suing for the recovery, that they didn't know about it. They're basically allowing them to file and letting the court determine if they're screwed or not. That's that's how I'm reading that. The law of another state alleged to differ from the law of the forum governing the liability of members of a business trust is not available where there is no pleading or proof thereof. Let me read that again. The law of another state, alleged to differ from the law of the forum state, right, governing the liability of members of the business trust is not available where there is no pleading or proof thereof. In the absence of such pleading and proof, the court will presume that the foreign law is the same as the common law of the forum. This is number 16. Let's see. Dunning versus Gibbs. If the trustees of a business trust organized in another state wish to avail themselves of legal principles prevailing in the other state, by which the trustees are immune from personal liability on the contract of the trust, in a situation where they would not be exempt from liability according to the law of the forum, they must plead and prove the law of the other state. So that's what it is, all right? You have to go in and say, prove it what this is over here in that the law in that state and why it should apply in this one. When I leave off at 16. And in order to avail himself of a defense based on the failure of the plaintiff, a business trust organized in another state to comply with the statutes of such state, a defendant must plead the statute. Conclusions by the pleader as to the power of the trustees will be treated as surplusage, extra wording, right? Where the trust instrument is pleaded in full and is contrary to the conclusions thus pleaded. And the same is true of conclusions with respect to the status of the organization as a pure true trust or a partnership. And that's because the paperwork governs, man, your words. If you're not interpreting it correctly, right? Say you're not a trustee of whatever it is that you create, all right? And you hire someone else, right? Well, if he does not understand your true intentions and interprets it correctly, then he's going to be using verbiage that is non-applicable to what is truly in the trust instrument. And the judge is going to determine that because, of course, the grantor might not be around anymore. You're hoping that you, as the grantor, is smart enough to know what to write in your paperwork, that it is definitive and not ambiguous. You're hoping for a smart trustee. Intrinsic evidence has been held admissible to show the intention of the contracting parties with respect to the question whether or not the trustee was to be exempted from personal liability on the contract made on behalf of the business trust. They say intrinsic, right? Intrinsic evidence. Isn't that circumstantial? No. Intrinsic evidence, as used in the context of a contract construction, is evidence relating to a contract but not appearing on the four corners of the contract because it comes from other sources involving the setting in which the parties negotiate the contract. So it's everything else. It's the letters that you guys sent back and forth between each other. It's personal conversations that you had between each other where you might have a witness and stuff like that. That's what that is. Where the contract is ambiguous on the question of personal liability of the trustees thereon, the question should be submitted to the jury with evidence of the surrounding circumstances and the concurrent dealings of the parties, and that's the same aspect. In an action by the business trust on a contract, it is not required to establish by positive proof its compliance in detail with the provisions of a statute relating to the manner of executing an instrument creating a business trust. Let's read that again. In an action by a business trust on a contract, it is not required to establish by positive proof its compliance in detail with the provisions of a statute relating to the manner of executing an instrument creating the business trust. And in an action on a conditional sales contract assigned by the defendant to the plaintiff trustees of a business trust, the defendant, by failing to deny or to make a special demand for proof of the plaintiff's allegations that they are trustees under the trust are assignees on the contract, admits to such allegations. As in other cases, the appellate court will not ordinarily consider issues or objections raised for the first time on appeal, which anyone who's been to the court before, an appeal is based, when you appeal of something, right, you are appealing some procedure that was not followed through. You cannot advance new evidence unless you can provide something that you were denied through some due process or some administrative process or something of the like. You know, that's they won't consider issues that were raised for the first time. And that's for everything, not just trust. That's in general. This is a good case right here, Illinois case. If the trustees of a business trust organized in another state, well, I already read this. I'll read it again. No, if the trustees of a business trust organized in another state wish to avail themselves of the legal principles prevailing in the other state by which the trustees are immune from personal liabilities on the contract of the trust, in a situation where they would not be exempt from liability according to the law of the forum, they must plead and prove the law of the other state. And I would think to add to it, right, in a similar situation that you're in here. So you have to prove that you would have limited liability in the state that you created it from, right, your forum state, right, in a similar situation, right? Like, you just because you wrote it in your indenture, right, doesn't mean that you're not absolutely limited liability even in the state that you're in, because there might be a statute, right? Some principle, I don't want to just say statute, right? Because some statutes, if not many, right, are based on principles of law, right, from the common law or equity that are part of the delegated powers that we, the people, gave to that government, whether state or federal. And those principles are what? Created statutes. Just like the Constitution. You have the Constitution, but then you have the statutes at large. The statutes at large are the first statutes. They're supposed to be in compliance with the law. And then from there, you get the regulations and stuff. You get the code and then the regulations. It goes down the line. In which a contract was executed in the name of the trust by the trustees with the word trustees opposite their names. So this is one of those situations where it's probably a president, secretary type thing, you know, and they have, let's see what this is, footnote 20. Intrinsic evidence has been held admissible to show the intention of the contracting parties with respect to the question whether or not the trustees was to be exempted for personal liability on a contract on behalf of the business trust. And it says in which the contract was executed in the name of the trust by the trustees with the word trustees opposite their names. So they were specific. You know, they gave qualification to their name on their signatures. Where there is an ambiguity in a note as to the capacity in which the trustees or officers signed the note, parole evidence is admissible. And this is, of course, verbal conversations, if you could prove it. You know, and even if you don't have no witnesses, you could argue it in such a way that the response from the other person could show that that conversation actually was had, you know. So as between the original parties to show whether such person signed in a representative or personal capacity. Where there is no question of identity, a misnomer of the plaintiff in an action by a business trust, or the fact that the trust did not bear the name which was used in the agreement by which the defendant subscribed for its shares, cannot be raised for the first time without pleading upon appeal. And this I'm going to read because I haven't had much experience in court. I haven't had real reasons to go to court. So it's like learning this ahead of time will always be a plus. And look at this. And this is a good case right here, commercial casualty insurance. And where a complaint was based on the theory that the defendants, shareholders in a business trust, were partners, the plaintiff cannot claim on appeal that the defendants are trustees and liable individuals as such because of their failure to include terms limiting their liability on the contract sued on. This is the one, the father and son construction company partnership, actually. And they transferred all the property and dissolved the partnership, where the father was the only beneficiary. He was a trustee also, but his son was also trustee. But the beneficiaries weren't the same. At least in Illinois, that's not a partnership. In some states, like probably California, that would probably be a partnership. Subsection 103, trial and judgment. In a jurisdiction in which a business trust may be sued in its adopted name, it follows that a judgment may be rendered against the trust in that name. The dismissal of the claim of personal liability against the trustee does not prevent the entry of a judgment against the trust, and a former action to recover against the trustees on the note executed by them has been held not to constitute an election to hold them in the exclusion of the trust estate, so as to bar a subsequent action to subject the trust estate to the payment of the note. Where the trust instrument authorizes two of the three trustees to act for the trust is bound by the judgment entered in an action defended by the two trustees. Trustees against whom a judgment was rendered on the theory that they were partners have been held to have no right to complain of the failure of the court to render judgment also against a shareholder of the trust. A judgment for the plaintiff in an action by trustees on behalf of a business trust is not subject to the objection of indefiniteness or uncertainty, where the trust is bound by the judgment and the defendant is protected against further liability. The individual property of a trustee may be seized on execution to satisfy a judgment against him on a debt or obligation of the trust estate. So this is you being hit personally liable. And a statute may provide that in a suit against an organization in the nature of a business trust, a judgment against it shall be equally binding upon the individual property of the shareholders or members who have been served with citation in the suit. And this first part, right? Say you choosing to do some type of activity in a jurisdiction that you can be held liable, right? Individually for whatever, right? Then it would be wise for that individual during at least the execution of that activity or contract, right? For him to have his own trust also, where he is not the trustee and has no partnership, no dealings, no powers, no nothing in that property anymore. So as that if and when he does get hit individually, okay, well, all his stuff is in trust that he has absolutely no control over. So what are they going to take from him in the end? Footnotes. The judgment reciting that certain named persons, trustees doing business, and that trust, I would make it for me. For what I would do is I would make it an ordinary trust, meaning that the trustee is just a legal title holder, and he has no real duties, right? And in the trust instrument itself, you are the one who told him what to invest in or what to do with the money, and that's all he's doing. He's watching it. So he don't screw up, right? So he don't screw up. That's nothing. All right, Part B, shareholders' actions, Section 104 generally. The courts have recognized that the holder of preferred shares in a business trust may maintain an action against the trust to enforce his rights thereunder, which is a given. That a shareholder can maintain a bill in equity to compel the trustees to perform their duty to distribute accrued profits. And that in a proper case, shareholders may maintain an action for an accounting by the trustees. Shareholders may also, in a proper case, be a representative or derivative action or a suit in equity for the appointment of a receiver for or the termination, and the dissolution or liquidation of a business trust. I guess something that's important here, right, is, okay, how they said that shareholders could bring action. This is a given, right? If you are fucking up, right, then they can prove that you're fucking up, well, they're going to bring action against you. But here, how they said, perform their duty to distribute the profits, right? If you have the trustees where they have discretionary power when to do it, right? And meaning it's not laid out every 3 months, every 6 months, or every year, right? Then here, a discretionary power they will lose in court. They can't force them to do something which they have power to do otherwise, right? And like even in the case of every 3 months, 6 months, or so forth, right? They could withhold, if they have the power to withhold those funds from being distributed, that in itself is a discretionary power too. But because the primary purpose was first to distribute, right? If the beneficiaries can show that you're withholding money for no reason, no real good reason that is for the benefit of the beneficiaries, right? Because ultimately that's what they're working for, right? Then they will win. The beneficiaries will win. But nonetheless, it's because the primary purpose was to distribute. Where if you don't write that and it's completely under the discretion, then you can't do nothing. You can almost do nothing. And here how it says, in a proper case, right? Shareholders may maintain an action for an accounting. Well, you're supposed to be able to, almost every state has something that because the point of the principles of trust law is that you need to have an accounting, give an accounting to the beneficiaries. But because you have bylaws, you could create bylaws, right? You could restrain that accounting to specific information and so forth. You can't deny them an accounting, but when you're talking about beneficiaries, could be anybody. Like if you have an investment trust that you create for business purposes, and investors could be anybody, well, damn, you want to limit that type of information. They have a right to an accounting, but they don't have a right to every single thing, every single detail of it. Just enough to show that you are not in violation of anything for sure. Shareholders may also, in a proper case, bring a representative or derivative action or suit of equity. I already read this, right? It has been held for the purpose of fixing the venue of an action between shareholders in a business trust, the organization will not be treated as a partnership. It has been held that for the purpose of fixing the venue of an action between shareholders in a business trust, the organization will not be treated as a partnership. Well, they talked about that earlier. What is it? The rights and duties inter se, right, which is between themselves, and that's in the section for this chapter for business trust under the shareholders, which was like 2 videos ago. And in an action between shareholders, the defendants are not bound by a judgment rendered in another state in an action against other shareholders to which such defendants were not parties. In a shareholders' action seeking reorganization and eventual incorporation of a business trust, it has been held improper to omit as parties shareholders residing in a certain state so as to create the diversity of citizenship necessary to give federal jurisdiction where such omitted shareholders could conveniently have been joined as parties. You know, there's a court case out of North Carolina, right? It's the Kimberly Kastner. Kimberly Kastner. Let's see if it comes up. I don't know the exact citation. No, that didn't come up. Kastner Trust, North Carolina. This one right here. For those who are in North Carolina, right, I highly recommend reading this because you won't find it in a book yet. This was just adjudicated in 2021. And if you find it in a book, right, if you find it in a book, the appeal was 2021, right? So this is the original, right? If you find it in a book, you're going to find it in your state. You're going to find it in the jurisprudence of your state. And that's where you want to look. You won't find it in American jurisprudence yet. You won't find it in American jurisprudence for years. And if you do find it in American jurisprudence, you'll find it in the supplements. Like they'll add, a booklet in the back of the book. Like they send out supplements to all their depositories and all the law libraries, right? Or customers, I guess, right? And put a supplement in there for that. But that's rare. There's so many books that don't have those supplements when they should, or they were taken, stolen, or whatever. It seems that mandamus will not lie at a shareholder's instance to compel trustees of a business trust to perform their duties under the trust instrument, pointing out that a shareholder's rights with respect to trust affairs vest in contract, not in statute. Damn, how much more I got? I didn't think that this was that long, because there's still one more. Oh, man. I went too far. I think I was supposed to stop on section B. All right, then. I'm just going to finish this then. I started here. I started this already. So I'm just going to continue. Yeah, I'm just going to continue. There's 4 pages left. So this will be the last video for business trust. Representative or derivative actions generally. The doctrine of virtual representation applies to actions by minority shareholders of a business trust and permits a part of the shareholders to maintain an action against the trustees for the benefit and as representatives of all of the shareholders. The shareholders may maintain a suit for an injunction against the trustees to prevent them from wasting, destroying, or dissipating the trust estate. A shareholder of an organization in the nature of a business trust may maintain a representative action against a director thereof to recover on account of the latter's fraud, without procuring or seeking a dissolution of the alleged partnership. A shareholder may maintain a suit to recover on account of the systematic exploitation of the trust by persons dominating the same, and to preserve and restore its assets, although he acquired his stock after the occurrence of the acts complained of, and shareholders have been held entitled to proceed in equity for rescission of transfers of trust property made under circumstances tinged with improper dealings, where the trustees failed to make appropriate action for the benefit of the trust. While a proper demand upon and refusal by the trustees to bring the suit is generally a condition precedent to the right of the shareholders to maintain the suit on behalf of themselves and of the trust, such demand and refusal are not essential where the circumstances make it clear that the demand would be refused. But where a shareholder brings a bill to seek redress of wrongs done to the trust, his rights are derivative and he must show some wrong to the trust. A minority shareholder has no right to maintain a suit to compel the performance of a contract for the conveyance of trust lands where the trust agreement vested in the trustee under the direction of the majority of the shareholders. Discretion as to whether to enforce the contract of sale or to retain and distribute the lands. The recovery of assets in shareholders' class suit inures to the benefit of the trust estate and so indirectly to all its shareholders, without priority of one over the other, and shareholders are concluded by a judgment in the proper representative action against the trustees. I keep forgetting what this word means. Inure, accustom to something, especially something unpleasant, to come into operation, take an effect. So in law, it means come into operation, take effect. Practice a negligence, nonfeasance, or ratification of wrongdoing as excusing demand on directors as prerequisite to bringing a stockholder's derivative suit on behalf of the corporation. Third edition, American Law Review. Demand requirement on board of directors as prerequisite to bring shareholder derivative action was excused where complaint contained allegations that defendant directors were parties to wrongdoing of improperly using corporate funds to process and mail solicitation material, acting to sell corporate property at artificially low prices, and breaching fiduciary duties since demand was thereby futile and unnecessary under federal rules of civil procedure. In a derivative action on behalf of the Massachusetts Business Trust alleging various improper acts on part of the trust investment advisor, the shareholder's complaint failed to sufficiently allege an excuse for failure to make a demand on the trustees of a trust, even though it was alleged that a majority of the trustees had authorized and participated in the allegedly illegal transactions, and that the institution of the action by the present trustees would place its conduct in hostile hands. And let's look up this. I know they gave the definition a second ago, but let's look it up. A derivative action is a type of lawsuit in which the corporation's assets in which the corporation asserts a wrong against the corporation and seeks damages. It is a legal claim brought by shareholders on behalf of a company to protect the public from corporate misconduct. But that's corporations. The process involves the written demand, representative plaintiffs, and court involvement to ensure adequate representation in best interest of the corporation. Derivative actions are an important aspect of continuing debate about corporate governance in many jurisdictions worldwide. Let's write BUISNES, since they talked about with trust. Derivative actions do not, however, exist within trust. I don't know what to say. Let's go back up here. I want to see this. The doctrine of virtual representation applies to actions by minority shareholders of a business trust and permits a part of the shareholders to maintain an action against the trustees for the benefit and as representatives of all the shareholders. Thus, shareholders may maintain a suit for an injunction against the trustees to prevent them from wasting, destroying, and dissipating the trust estate. This is not pertaining to public, like a corporation. Where did I go at? Right there. So these are footnotes. That was a supplement, so these are footnotes. Yeah, that was a supplement. A shareholder of a business trust was held to be entitled to maintain an equitable action against the trustee to restrain the latter from voluntary paying of tax illegally assessed by the federal authorities. This is a good case, Weeks versus Sibley. There's also other aspects to this case. Man, I gotta look at the case to remember. That's crazy. A shareholder of a business trust was held to be entitled to maintain an equitable action against the trustee to restrain the latter from voluntarily paying a tax illegally assessed by the federal authorities. You know what the hell was it? It was the beneficiaries who filed suit to stop trustees from paying a tax, who, in their view, at the very least, right, thought it was an illegal assessment by whatever. If I remember, it was the assessment of real estate. Wherein the court stated that the holder of transferable shares has the right to participate in all of the assets of the trust, including assets wrongfully diverted from the trust before he obtained his shares. The omission of an allegation as that the remaining assets of the trust are insufficient to protect the present rights of the shareholders does not defeat his right to maintain a suit to vindicate the rights of the trust and to preserve and restore its assets based on a systematic exploitation of the trust by persons dominating it. And these two cases, they go well together. Massachusetts case. So that's what this is. This is District Court for Illinois. A shareholder's action against one occupying a position of promoter, director, and entrepreneur of a business trust whose affairs he dominated, controlled, right? But who was neither officer nor trustee, and so required to account for his dealings with the trust, exhibiting bad faith and violation of fiduciary duty. One thing that I should recommend for everybody, which is what you guys see me doing all the time, is you want to create folders for every section that you're reading. Like in this case, we're talking about actions in court. Okay, so if you have an idea of what jurisdiction you want to create your trust in, okay, well, man, copy and paste and do researches on these court cases so that you have them in your file. You will have to read them. And then even better, if you're able to write specific notes. Like, it's one thing saving them, right? But then writing a note after you have read them, whether it's the file or a separate page completely in the folder, is so you know and what to use, and you're not lost, right? You won't be lost in terms of what you're looking for to be able to defend yourself, what court cases you could use to defend yourself, defend the trust, not yourself. Well, yourself, in case you're liable, but you know what I mean. Shareholders have been permitted to maintain a suit against trustees to cancel a transfer of property by the trustees to the trust. Thus, such demand and refusal are not a prerequisite of the right of shareholders to sue, where the purpose of the suit is to remove the trustees and obtain an accounting for their unfaithfulness, and to set aside illegal transactions entered into by them, since it is apparent that a demand in such case would be futile. In all reality, most of these, right, man, there's only one thing you should be doing. And be faithful and honest in your dealings. Own up to what the contract says if you're the trustee. If you're looking to escape, and violate laws and shit, man, this ain't for you. You just looking for jail time, like for real, like those people who believe statutes don't apply to them, like are morons. There ain't no other way. They're morons. There ain't no other word. Ignorant maybe is a better one. As to the right of shareholders to determine whether or not an action will be instituted by the trust and to use the name of the trust as plaintiff. All right, Section 106, proper or necessary parties. In a suit by minority shareholders of a business trust against the trustee seeking an accounting, the appointment of a receiver, and a winding up of affairs of the trust, it is not necessary to make all the shareholders parties. Well, that should be a given, because why? The trustees have all the pertinent information that they would need. So too, one of the several beneficiaries of the business trust may maintain an action for removal of a trustee without the necessity of joining the other beneficiaries. While all the beneficiaries are proper parties, they are not indispensable parties. Also, in a suit by shareholders against the trustees of a business trust for an accounting by the latter for the recovery of sums misappropriated or lost by the trustees, and for the appointment of a receiver, the trust in its distinctive name was held not to be a necessary party. The present trustee of a business trust is a proper party to an action by a shareholder to vindicate the rights of the trustee of the trust and to preserve and restore its assets. A proceeding to remove a trustee is adversary in character, requiring that the trustee sought to be removed be made a party and be given notice of the proceeding. So, like, if you're going to be removed, you got to be a party. Like, if you're going to be, if someone's looking to remove you or remove a trustee, you have to be a party. That's should be a given. They can't remove you on some secret shit. Like, that just don't happen. You got to be able to be given due process of law. However, a proceeding to fill an existing vacancy or to accept the resignation of a trustee and appoint a successor may sometimes be ex parte. And this right here is dependent if it's not in your trust indenture. Here, you're in court because the powers in the trust indenture are not there. You gotta plan for that. But the joining in an action by shareholders of a business trust to remove trustees, compel an accounting, and cancel a transfer of trust property to a corporation of shareholders who have exchanged their shares as part of the challenged transaction for shares of the corporation and who sought a rescission of the exchange of their shares was held not to be multifarious. I never heard of that word. Multifarious. Many and various types, having many varied parts or aspects. It's held not to be a multitude of aspects, right? Since their prayer to be restored to their former status as shareholders in the trust called for relief that was merely incidental to the main relief, which they sought in common with other shareholders. Further stating that the trustee owes the duty imposed by his office to each and all of the beneficiaries. The possibility of a judgment for the trustee in such case would not or might not protect him against similar actions by other beneficiaries is an inadequate reason for denying the right of one or more beneficiaries to proceed without joining all the beneficiaries in the action. Wesson Crane, Supra, stating that the probability that a beneficiary bringing a groundless action against a trustee would be charged on the books of the trust with the trustee's expenses of litigation is sufficient protection against multiplicity of suits seeking removal of a trustee. Looney versus Wing, Supra, stating also that this is especially true where a majority of the stockholders join in the petition, a circumstance which may invoke the doctrine of virtual representation. I would look this up specifically, like completely, and find an actual PDF, actual law on it, like Washington law, the doctrine right here for California and Texas. Let's see if I can find it. In Illinois. Articles of Virtual Representation Doctrine, Illinois Bar. I want a PDF. But that case right there, it's a federal case though. Let's see if I can find a PDF. Since I don't know what that really is, aside from what we just read, right? I never had to participate or do some action like that. This has charts. Let's see what comes up. So this, what year? 2000. So this is for the states. Find the states. They don't give you a statute. So that kind of sucks. You know, to specifically go find it. Well, here they did. No. I don't know. I'm not going to get into that one right there. Not now, at least. I'll look it up later. Section 107, Accounting. The shareholders of a business trust may, in proper case, maintain an action for accounting against the trustees, and the court may, in a suit by shareholders against the trustees for an accounting, compel the trustees to produce for examination the books kept by them. However, an accounting by the trustees will be ordered by the court only where it will serve some definite and useful purpose. The substantive rights and liabilities of the parties in an accounting action depend, of course, upon the terms of the trust instrument and the particular circumstances of the case at bar. In a proceeding for an accounting by the trustees of a Massachusetts trust, the burden is on the trustees to show that in the discharge of their duties, they have exercised reasonable skill, prudence, and judgment. But where the trust instrument vests in the trustees of a business trust absolute power to manage and control the property and the business of the trust, and provides that the shareholders shall not have the right to an accounting Shareholders cannot maintain a suit against such trustees for an accounting in the absence of showing of an abuse of power or wrongdoing or a misuse of the trust funds and trust. But here's what I want you to understand too is like, at least in this state, let's see what state that is. Pennsylvania, right? In Pennsylvania, it's not a mandatory thing that you have to give an accounting. In most states, like Illinois, you have to give an accounting. Here, they don't, for whatever reason, unless proof of fraud. And I would think for the most part is to protect the business itself. Meaning, like the example I gave, an investment trust where you have multiple shareholders that you don't know. You just sold them some shares to benefit the business, right? To promote the business, right? Well, it's all about being able to protect the assets of the proprietary information and technology or property that the trust owns. So it's like, and I agree, I wish Illinois was like this, but it's not. Footnotes. Shareholders may maintain a suit against trustees. Did I read all? Yeah, I did, right? Shareholders may maintain a suit against trustees for an accounting for proceeds of trust property wrongfully detained by the trustees. The heirs of a deceased shareholder of a business trust may demand an accounting for the trustees. Yeah, that's because personal property was transferred by will. It was indicated but not decided in Small versus Smith, which is the one we just read, that if shareholders were entitled to an accounting from the trustees of a business trust organized in another state, they should apply therefore in the courts of the other state. And that if shareholders were entitled to an accounting from trustees of a business trust organized in another state, they should apply therefore in the courts of the other state. In charging a trustee with sums lost to the trust estate by reason of his misconduct, he should not be charged with the proportion of the loss represented by the shares owned by the shareholder who participated in the misconduct. In Ashley, where the participating shareholders was the dominant shareholder and was largely responsible for the misconduct of the trustees. And that's it, everybody. That is the whole chapter on business trust right there. What I highly encourage everyone to do is go to their law library. Get the books, at least one book for trust law in general. You have to know the principles of ordinary trust. Then get books on business trust. I favor the jurisprudence books. I am a big case law reader. I don't care for the statutes so much. Why? Because the statutes usually are creating a statutory version of what it is that you're creating. So you do want to read your state statutes on trust law generally, but understand that when they talking about certain aspects of those trusts, they are talking about what it is that creates that type of trust under statute. So be aware of that. But no doubt, case law is by far the best information you will find anywhere on any topic that you ever want to research. Anyone who says otherwise does not have a library. They absolutely do. I have a vast library in the years that I have been studying. This is what I do. I do not work anymore. Why? Because I don't want to. I don't need to. All I do is research law. That's it. So I congratulate everybody who has made it this far. Hopefully you guys have watched all the videos all the way through. And like I said, I will be creating videos on top of these that will be specific to sections. So like, I'll make maybe a video specifically for accounting. That's a maybe though. Accounting is like a given. But maybe for like shareholder or taxation ones, or blue sky videos, security acts, but it will be specifically attached to that video that I already made for on this book, on this American Jurisprudence book. But for me to want to do that at a high volume, right? I need to be encouraged to do that, meaning that I know that there's people that have or are willing or to watch my videos. I mean, like, otherwise I'm making the videos for myself, because in reality I am, right? So I don't have to read this document again. All I have to do is listen to myself. So to each their own. Hope you guys enjoyed. For sure, like and subscribe to the Butterfly Monkey channel, and pay attention to the videos that are to come, because I will be speaking about a variety of topics. Just business trust was first. Have a good one.